There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
I'm in jail for $1,200 if admitted. All right, folks, today we've got another case to look at. I don't think this girl is really a sovereign citizen. She just decided to use the script. What do you think? Does she actually believe what she's saying, or is she just reading it off? She's in court for violating probation because of drug use, and instead of getting a public defender like any reasonable person, she thought it'd be smart to defend herself. You can probably guess how that's going to turn out. If you enjoy this kind of content, don't forget to like and subscribe.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
She completely lost her chance to defend herself. I'm honestly surprised she hasn't started one of those sovereign citizen rants claiming the court has no authority over her. In a way, I'm glad she didn't, because that would have been a disaster. But here's the thing, if you're representing yourself, this is your one shot to make your case, explain your side, and show the judge you're not completely out of touch. Skipping it or messing it up is basically admitting you have nothing. What do you guys think so far? Let's dive back in.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Anyone else feel bad for this girl? Yeah, she's a criminal and probably not a great person, but watching her embarrass herself like this is just rough. She could have had a lawyer, one who was free and ready to help, but she straight up dismissed him. I just don't get why these sovereign citizens think this way. Meanwhile, her lawyer was just sitting back, sipping his coffee, totally unbothered. Do you guys feel sorry for her, or do you think she's getting what she deserves? Let's get back to it.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
$1, $200 per minute. This is insane. Asterisk asterisk, this sovereign citizen is in jail but actually thinks she should be released, even after endangering her child, using drugs, and being a terrible parent. She already violated her probation, and now she wants to be paid for her time behind bars? Ridiculous. At first, I felt a little sorry for her, but after thinking it over, nope, I take that back. If you break probation and put a child at risk, jail should be the least of your worries. On top of that, she made a rude, almost threatening remark to the judge before her arrest. It wasn't a direct threat, but it was definitely disrespectful, and that shouldn't fly in court. Now, she's facing the consequences of her actions. No payout, no special treatment. But for some reason, these sovereign citizens think rejecting the court's authority gives them the right to demand money for being locked up. News flash: the system isn't rewarding her. She's just getting what she deserves. What do you guys think? Does she have any chance of getting out of this mess, or is she completely screwed? And do you think she'll actually get that $1,200 per minute? Yeah, right. Drop your thoughts in the comments. Don't forget to like this video, and if you enjoy this kind of content, hit that subscribe button. Thanks for watching. Stay safe.